filed in nature of a PIL, but strictly it didn't fall under the rules because it is in our interest itself, because it's more like a class action of the Association of Nurses of various central government-run hospitals.
So initially filed it as a PIL.
Initially, we filed it. We have withdrawn it. I'll just point out to that order, Your Lordships. That order is at page 62. Is that no? But there's no. Page 62. Your Lordships.
All right, yes.
So we have withdrawn it with liberty to file before Your Lordships.
Yes.
I just wanted to bring that to Your Lordships' notice.
Yes.
Your Lordships, on the merits of the matter, there's a Supreme Court judgment at page 400, Your Lordships. This was a matter with regard to central government employees of the Customs Department.
No, what is the policy in question here?
There's no policy. What we are asking from Your Lordships is, what we are asking is that there should be a spousal transfer policy, especially in hospitals, because these are nurses which have very...
Spousal transfer policy meaning
thereby, if one spouse is posted in one hospital, the other spouse should be given an opportunity to seek a transfer to the same hospital. Like we have in civil servants here.
The hospital in question being Aiims here.
Aiims and JPMIR, these are all central government hospitals, Your Lordships. It's not just limited to Aiims.
But isn't Aiims governed by its own rules and regulations?
Yes, it's under its own statute. So the statute also has conditions of service to be provided, Your Lordships. So in the conditions of service, Your Lordships, we are praying. This is like a Vishaka thing.
So assuming one spouse is say posted in Delhi.
Yes.
And the other one is in some other center. In Tamil Nadu.
So DOPT regulations for the central government employees provides that there can be a transfer if you're a central government employee versus a central government employee wherever, like IS officers.
But then can Aiims be clubbed with other central government hospitals?
Yes, Your Lordships, because I'll show from the statute it's...
Is that the issue?
Yes. It's controlled by central government.
Before my learned senior proceeds, my lords, it's at the end of the day a question of conditions of service. So, per se, the High Court won't have any jurisdiction. It will have to go to the tribunal, my lords.
No, this is an article.
Have to go to the administrative tribunal, my lords.
It's an article 50 rights that are paid.
Under Chandra Kumar also, conditions of service, it's best with the tribunal, my lords, on the administrative tribunal side.
Okay,
I wouldn't know personally.
Association is canvassing the interest of its members. There's no particular... There's no cause of action attributable to any particular person here.
Per se, my lords, the association can also approach the tribunal on behalf of its members. It happens routinely. At the end of the day, the question is, my lords, it's recruitment and conditions.
Are matters concerning the employees of Aiims subject to jurisdiction of the...
It is, my lords.
The Lordships, but
Aiims is notified in that.
I'm agitating under an Article 15 and an Article 21 right. This is much more than a simplistic condition of service. This is a women's empowerment issue. This is an issue under Article 21 because Lordships have held that right to family is a part of my right to life, to live with dignity, Your Lordships. Plus, it's a special provision that will be required to be made under Section 15, Article 15, Your Lordships. So this is a constitutional issue, much more a constitutional issue than a bare conditions of service issue.
All this can be adjudicated by the tribunal. All these issues can be adjudicated by the tribunal.
Lordships, whether the tribunal adjudicates it or Your Lordships jurisdiction cannot be taken away.
But my lords, efficacious...
It's the same thing.
Have to be exercised. Other alternate efficacious remedies will have to be exercised before powers under 2 to 6 hours.
Not efficacious. What is efficacious is the jurisdiction.
The only problem with what you're saying is this is not strictly a service matter.
Per se, it's strictly a service matter because at the end of the day, they're asking that they should be allowed transfer. DHO's work is already available under policy. Transfer, my lords, is an incidence of service itself. There cannot be any service unless there's transfer.
By that analogy, Vishaka was also purely conditions of service, Your Lordships. But that was again a jurisdiction which was exercised because there's a vacuum here. This is not as if they have a policy and I'm challenging the policy. That would probably be more appropriately dealt with by the tribunal. Here there is a vacuum. I am coming to Your Lordships in Your Lordships constitutional jurisdiction. This is not something which is a per se condition of service. So even Vishaka was with regard to conditions of service, safety
They're
at
asking for a
workplace.
positive direction that you frame a policy to effectuate their Article 15 right.
But still, my lords, we have
may not fall strictly within the jurisdiction of the. To file a counter, we'll see.
In fact, Your Lordship,
my rights
the
for
prayers
jurisdiction may be left.
in the writ also,
Rates are
B
junior.
and C especially, that would not be maintainable. Prayer B and C.
Sorry?
Prayer B and C itself
Yes.
would not be maintainable in a writ jurisdiction, Your Lordship.
That's precisely what I'm saying is amenable to Lordship's jurisdiction. Lordships may see.
You're right, it would not be maintainable by before CAT.
No, even in a writ jurisdiction, this to issue guidelines, especially C. So, she's seeking appropriate writ order direction under
The
Article
petitioner is
226
seeking a positive direction.
to issue guidelines. So the court is to issue guidelines, not the authority or the. This itself would make the writ
The
non-maintainable.
thing is, the plea is that to give effect to the petitioner's Article 15 right, you must, a positive direction is short that you be directed to frame guideline or adopt the DOPT guideline.
Please,
So
Your
at
Lordships.
the end of the day,
Vishaka.
only
Also, Your
central government or Aims would formulate the policy or guidelines, Your Lordship.
Yes,
Not the
yes,
court.
that's what they want you. That's
Yes.
what they want you to do.
So in fact, there is a RTI they have already filed.
You are for Aims. Who's for Aims?
I'm for responding to Aims Delhi, man.
For Aims,
And
Delhi.
Only for Aims Delhi.
You should be supporting the petitioner.
My lords, on merits, my lords, what the case is, the assumption that they're going on is that all aims are connected. But in reality, my lords,
Assumption that is going on is?
all aims are connected, my lords. Aims, Rishikesh, Bhubaneswar, all of them are connected. But in reality, each aims is a constituent autonomous body on its own. Having distinct cadres, distinct seniority lists, conditions of service may also be different. In those circumstances, what they're taking analogy is from the All India services. The All India services, my lords, is a common All India cadre. They have a common All India seniority list, which allows, and my lords, when you get appointed under the IAS, you have an All India transfer liability also. On the other hand, my lords,
Every Aims is governed by a different set of statute, is it?
they have their own, they're all autonomous, my lords.
What do you mean
Aims,
Autonomous under
statutes
what?
are a nurse, my lords, employed by Aims Delhi.
They are operating under the framework of a statute?
Yes, there's a statute, my lords.
Wait, there's a common statute for all the
There is
Aims.
a common statute under which all aims are constituted.
So why can't there be some common service rules?
Well, as the common service rules are not there because a nurse appointed in Aims New Delhi has no transfer liability that she can be transferred out of Aims New Delhi to Aims Bhubaneswar.
So every Aims frames its own service rule.
Well, as the service rules may be adopted, but each Aims has to adopt its own service.
I will.
They may be common or similar, but they have to be adopted each by their own respective governing bodies. There's no super body which will undertake the exercise of monitoring.
How many staff members are there? How many nursing staffs are there who have their spouses also in?
Your Lordships everywhere. That's the problem. One person is in Delhi, another gets his appointment because these are exams.
Only difficulty is that you don't want transfer from one Aims to another Aims. You want every.
That is what we are asking because even in central government, what is permissible, and these are also permissible.
Assuming you are in Aims Delhi.
Yes, sir.
And your spouse is in Tamil Nadu,
Yes,
central
sir.
government hospital.
Yes, sir. Yes, Your Lordships.
Then you want that you be transferred
Yes, because Your
to
Lordships.
another central government hospital.
Yes, that's what happens to IAS officers. You are Tamil Nadu cadre and you are Delhi cadre. Your cadre itself is changed.
But that's a common service, no?
No.
Common
but this is also common, comes under the common
India
control.
No, I mean,
It's common control. It's only for the purposes of administration of the property and the institution regionally. These are like regional centers having autonomy or under the parent act.
there's a counter come will.
Yes,
Under
there's a
IAS,
parent act.
there is a UPSC which undertakes the
Under
exercise.
this-
Here, my lord, there's
I
I
am
appeal for union.
No normal rate. Yes.
And there's a common
appeal for
board
union.
also, Your Lordships.
Yes.
Grateful. Your Lordships is making returnable in
19th September. Item 36.
Lordships
Exemption is allowed.
little earlier than national.
When you wanted July and
Yes,
July and
30th July.
yes.
very grateful.
Item 36.
Grateful.
Yes.
Lord, in 36, I beg to appear for the petitioner.
Yes, we'll raise it for hearing sometime.
Yes,
Yes,
my lord.
my lord.
And in the
The only-
meantime, I'll respond to their affidavit also.
Which
Yeah,
affidavit?